National Security Advisor John Bolton failing to appear for a voluntary interview Thursday as part of the impeachment inquiry. House Democrats saying they would not subpoena Bolton, but instead use his absence as evidence of President Trump's obstruction of Congress, likely to be one of the articles of impeachment drawn up by those leading the probe. All this as acting White House Chief of Staff Mick Mulvaney defied his own subpoena to testify Friday morning. Justice Department and White House lawyers have argued that the president's top aides have absolute immunity from congressional subpoenas and cannot be forced to testify before Congress. Let's bring in constitutional attorney David Rivkin. He served in the White House counsel's office during the Reagan and George H.W. Bush administrations. David, welcome. Thank you for coming today. So, David, how strong is this president's case for saying that his aides don't have to testify because of this immunity?
Very strong. It is a well-established immunity. Paul, dates back to 1971. OSC opinion written by young William Rehnquist, who, as you know, went on to be the Chief Justice of the United States, been reaffirmed in 9 administrations under both parties. Fully consonant with existing case law. It's a very simple proposition. It's called the immediate advisory immunity. So there's a discrete group of people who see the president every day.
Right.
He communicates with them. As 1971 opinion says, the president is a co-equal branch. He cannot command that members of Congress appear before him. They cannot command that he appears before them. Most people are essentially his alter egos. But I want to emphasize one more point. The reason the president is in a very strong position, there's another form of absolute immunity that is based upon 1989 opinion by Mike Luddick, also OSC opinion. He went on to be the chief judge in the Fourth Circuit. That stands for the proposition that national security information, no matter in whose hands it is, cannot be shared in a compulsory fashion based upon something even more venerable than 1989. It's called state secrets privilege. So we have two immunities working together because, of course, the president's, the people are being asked to testify not about some domestic policy issue, Paul, but because of national security, clearly.
Does any of this change, this immunity change, because it's part of an impeachment probe, which is a core power of the U.S. House?
It's an interesting question, never been litigated this way. I would like to think that even though it's impeachment power, impeachment does not reshuffle the separation of powers. Both of his immunities are anchored in the president's status as head of a coordinate branch. I don't think so, but to be fair, it's never been litigated in the impeachment context. Right. But let me emphasize one thing. The House lawyers are not very sure of their position. There's been a very surprising minuet where they withdrew the subpoena directed at Mr. Kupperman, who was Bolton's deputy.
Right.
Because they did not really want and they then went on their own to the judge in district court and asked the judge to dismiss the case. Does not sound to me like they really want to litigate this matter.
That's what I want to press because, okay, so Judge Leon, Dick Leon, Richard Leon basically threw them out of the court, as I understand it, and said, sorry, does this mean he's going to rule on this?
I believe that the case would go forward. I think he would rule on it. I think this is, among other reasons, the letter that was sent to Mr. Kupperman's lawyer, Chuck Cooper, basically indicated we're withdrawing the subpoena now, but we're going to resubmit it again. There's this concept, particularly in the D.C. Circuit, Paul, hate to be legalistic, it's called capable of repetition evading review. So if it's going to come up again, might as well do it now. My fear is that the Democrats are not serious about litigating this, knowing A, they might lose, B, is going to take a long time, just going to stick an article of impeachment accusing the president of obstruction.
Okay, if that's the case, now if they have dropped the subpoenas to have people appear because for whatever reason, either time or because they think they'll lose, how can you have an article of impeachment saying the president obstructed if you haven't litigated the issue?
Excellent question. In my opinion, the answer is no, but I heard today a statement from House Democrats indicating that the mere fact, forget litigation, Paul, the mere fact that President Trump ordered people not to testify is evidence of obstruction. Appalling, because there's another set of OSC memos that stand for the proposition that standing in your constitutional prerogatives can never be possibly a bad or unlawful conduct.
All right, let's turn to the New York tax case, where the district attorney in New York is subpoenaing the president's accountants, Mazars, for the president's tax returns. President has resisted that, claiming he has immunity from investigation for private acts before he took office. But the Second Circuit Court of Appeals this week said he has to turn those over. The president is going to appeal. How strong is the president's case here on this tax case?
More difficult case, Paul. Let me say a couple of things. First of all, it's a carefully written opinion, unanimous opinion, Second Circuit pointing out, but the sitting president on OLC learning cannot be indicted but can be investigated, just like Mueller investigated him. Saying, what's the big deal about investigation? A couple of things. First of all, it is investigation, I hate to be formalistic, by state, which is a different sovereign than the federal government. There's less federal control, if any, over the possibility that the documents would leak, the testimony of accountants might leak. Second, it's not obvious what's the rush here. Look, does anybody believe who is listening to us now, but this investigation is not about, it's really an investigation into some tax return matters. This is not an investigation to get Trump. The OOC learning as to why this sitting president cannot be indicted uses a simple pragmatic lodestar. Is it something that really impedes the president's ability to function? And I think we have to accept that in the current environment, it does. Therefore, you know, there's a famous Paula Jones case where the Supreme Court allowed the civil case to proceed against President Clinton. But again, why? Because they did not conclude a single case would be debilitating. You know how many cases are pending against President Trump?
Yeah, there are a lot of them, David. For those listeners who don't know, the OLC is the Office of Legal Counsel. I assume that this case is going all the way to Supreme Court, and we'll be back to talk to you again. Thank you, David Rivkin.